Thank you very much, Grant and President, for your words of welcome. I have not actually applied for an academic position at Western, but I do hold an honorary professorship here. Although being unpaid, I rarely show up. And when I do show up, I tend to get into fights with your professors. So it is surprising that I have been asked to give this lecture, because undoubtedly we will all be on a collision course by the end of the evening. Because this matter of judging the judges is something on which you reflect as a door closes and you, in my case, leave the bench after almost exactly 14 years. And in that time, you read a lot of cases, you meet a lot of judges, and you ask yourself really what makes, by what criteria should you judge the judges? What makes not only a good judge, but a great judge? And I put in the title to the talk, Ivan Rand, because I believe he is one of the greatest judges that Canada has produced. But there are others. He's part of a tradition that has moved the judiciary more to the center of the development of the law than some of your professors would like to see. And therein lies part of the collision. I believe that in the Supreme Court of Canada there are two traditions. There is the tradition of the Ivan Rand, Lyman Duff, Jean Betts judge, who really took the law as an instrument to carry forward in a very incremental and orderly way a vision of society. They saw their role as having a broad significance, a broad mandate, not to usurp other functions of or other branches of government, but that it was necessary for the judges to intervene, to oil the machinery, to make it work. There is another tradition. In my time before the court, I think it was exemplified by Roland Gartland, who was much more of a black letter law, and people like Fauteux, Renfray, quite often Quebec judges, because of course they're brought up in this tradition of it's all written out in the civil code, and what you have to do is to derive the law from what is written. But I think when you look at the clashes in the 1970s and the 1980s between Justice Martland and Chief Justice Laskin, you see this tension of very different views of how judges should be judged. My own approach to this is that I think in our system there are checks and balances, and that being elected is not the only source of legitimacy. It is important that some persons who wield power within the constitutional framework cannot be removed quickly by popular will. I think to the great prorogation issue and the matter pending before the Governor General, and if the Governor General had been there and at the possibility of removal at short notice by the popular will, then you would not have had this balancing act that went on as between what the Governor General of the day saw as responsibilities to uphold the Constitution and the view of the government of the day as to what was required. Now, I don't want to be misunderstood as suggesting, by talking about go boldly where Justice Rand went before, that it's all about boldness and creativity. I think this function of lubricating the operation of the legal system as often calls for restraint as it does for creativity and boldness. But I believe that there are occasions in the history of Canada when we would have been very badly served by the Roland Gartland approach, and we were very well served by judges such as Ivan Rand. I think the opponents of the school of judging that I support point to the Quebec secession reference of 1998 and its propounding of unwritten constitutional principles probably represents the most objectionable manifestation to the black letter law critics. Professor Jamie Cameron said the whole thing was deeply disturbing. Peter Hogg said, these vague principles conjured out of nothing can be brought in aid to address almost any grievance that anybody can think of. And this is a sort of academic proclivity for saying, well, because there's a door, fools are going to rush through it and act irresponsibly. Whereas I think the judges who participate in these decisions are faced with a dilemma. And I'm going to come to the Quebec secession case because that was a case heard in the first 2 weeks that I was on the court. And in that time period, the protocol on the court was when we conferred, they would turn to the most recently appointed judge and say, well, what's your opinion? So it was a fairly brutal introduction to what is judging all about. But Ivan Rand made no bones about the rule of law not being incompatible with what we would today call social engineering. He, I think, understood the law as I do, which is a view sometimes attributed to Oliver Wendell Holmes, that really what the law consists of is a prophecy of the courts will do. The great philosophers of the National Post last Saturday, George Jonas, said, well, nobody knows what the law is until the judge says what it is. But that, looks at it from a perspective removed from the bench. When you're on the bench, you can't operate on the basis, well, I'll do what it's predicted I will do. You have to kind of have some guidance in your own approach to the problem, quite independently of what others might predict. And in the Quebec secession reference, which, as you will recall, the court was asked 3 questions. The first was, if there was a unilateral vote in favor of secession in Quebec, would it then constitute or trigger a constitutional right for Quebec to leave Confederation? Would it be constitutional? Alternatively, would it be under international law the right of Quebec to exit under the principle of self-determination? And then if the answer to those two questions differed, which would prevail. The federal government took what I would describe as the Roland Gartland approach, saying, well, read the Constitution. Where does it say anybody can leave? You won't find it in the Constitution. And therefore, if Quebec wants to leave, they have to get all these other provinces to agree under the amending formula, and only then can they leave. But not a very realistic answer. If you had a vote and you had momentum in Quebec towards independence, and Quebec said, look, democracy, we live in a democracy, the pleasure of the people is known, the majority is spoken, we're out of here. But on the other hand, the argument of Quebec was equally unpalatable, which is the only constitutional principle worth looking at is democracy. And all of the other checks and balances in the system have no weight. Once democracy expresses itself, then the people will have their way and Quebec may exit. And the court came up with a number of principles saying, well, yes, democracy is critically important, but so is the rule of law. It's not consistent with our constitutional values, even if we are a democracy, to create the kind of chaos that would result from an immediate disengagement of Quebec from the rest of Canada. I mean, there is this vast interlocking of relationships, commercial, economic, social, cultural, that have grown up in the years since 1867. And it cannot be that a unilateral decision by one element of the Constitution prevails instantly. That our tradition has been not unilateralism, but multilateralism. And that the whole principle of federalism is that a certain weight is given to the views of each of the component parts, so that the democratic expression in one part of the federation should not necessarily trump the equally strongly held democratic view in the other units of the federation. So what the court was saying is, look, if you look at how we govern ourselves, and you see the actual pragmatic and practical problems posed by this hypothetical question, the court has to dig a little deeper. So did the court just make all of this stuff up? Well, it seems to me that the court didn't. Those decisions that the court took, that the rule of law governed essentially how Canada would proceed to deal with a hypothetical vote in favor of separation, has roots going way back to the beginning of the Supreme Court jurisprudence. Now, I know in this law school there are those who talk about constitutional romantics. And the view is that what I'm talking about as what I think are the good and the great judges proceed on the basis that they have a superior insight, a superior wisdom to the elected representatives. And that those who support believe the worst of the elected people and the best of the judges. Well, Ivan Rand spent most of his career in complete conflict with that proposition. I think he found his voice really in the case of the deportation of the Japanese Canadians. And that was a disgraceful measure passed under the War Measures Act after the war was over, that said to Canadians of Japanese descent either naturalized or born here, most of whom who'd never been to Japan, that they would either have to move away from the coast into the horrors of Ontario or be deported to Japan. And Rand said, look, this is a popular measure. There was a tremendous visceral hostility to people of Japanese descent because of the stories emerging of what had happened in the Pacific during the Second World War. And Rand said, that's got nothing to do with these people. Most of these people have no connection with Japan other than a bloodline. And it would make as much sense to deport to France those French Canadians who spoke in favor of the Vichy regime as to boot out Japanese Canadians who'd been here for generations. But the majority of the Supreme Court said, look, elections occur, governments are in place, governments pass regulations, governments are responding to the perceived view of the electorate, and the measure was upheld. Well, it seems to me that Rand was correct in putting this gloss and saying, you know, fundamentally, this is such an arbitrary measure, it cannot be considered consistent with the rule of law. Just as more recently the court has said, look, one of the principles of fundamental justice is that you're not to be denied of life, liberty, security of the person arbitrarily. And Rand had picked this out in the 1940s as, in his mind, essential to the functioning of our constitutional system. So you come forward to the cases of the Jehovah's Witnesses. The people of Quebec spoke. The Jehovah's Witnesses had to be crushed. These people were distributing pamphlets which were not only heretical, but blasphemous in their treatment of the Church, the Roman Catholic Church and the Roman Catholic priests. Boucher and the Queen, this, Quebec's burning hate of Christ, and that what's wrong with Quebec is priest domination. And all of this stuff was being pumped out and carried from door to door to door to door. And du Plessis said, enough of these people. And moved in, and as we know, in a whole series of cases, Rand, speaking for the Supreme Court, said, yes, democratic will, great, but there's other principles at play in here. And you've got a minority which has been harassed, really, by the Roman Catholic Church, hand in hand with the government of Quebec. And they've got a right to speak out, and they've got a right to hold the views they do, however odious they might appear. And there was precious little in the Constitution that enabled Rand to make that declaration and to pull the court in behind him. To him, it was just inherent in the rule of law that this kind of arbitrary abuse of power could not and would not be tolerated. The same with the communists. Trade union in Nova Scotia elects communist leadership. Nova Scotia Labour Board refuses to certify it. Rand says, what's wrong? He said, yes, there's the Red Menace. Yes, we're all worried that the Russians are going to take over the world. But this is a little trade union in Nova Scotia. And these people are saying what they think. We may think they're crazy. We may not agree with them, but that doesn't mean that the election is void. And Supreme Court struck down the decision of the Labor Relations Board. So you see, percolating all the way through the jurisprudence was this notion that the Constitution isn't all in this text of the 1867 statute. It's not all in the preamble with the Constitution similar in principle to that of the United Kingdom. there are certain basic underlying values that we as the Supreme Court are responsible to give effect to. And we're going to give effect to it. Sometimes it was rationalized under the division of powers. Sometimes it was rationalized as abuse of power. Sometimes it had different ways of reaching the conclusion they wanted to reach. But fundamentally they were saying the rule of law doesn't permit it and we're not accepting. And before Rand, of course, you had the Alberta press case. Alberta, the funny money government of Eberhard said, look, newspapers in Alberta are going to be required to publish press releases from the government that will respond to arguments about funny money, and we will explain, and you will print exactly what we tell you to print in response to these heresies against the social credit. And Sir Lyman Duff, God bless him, he's not a flaming radical. And he said, you know, freedom of speech, freedom not to speak if you're a newspaper, freedom to refuse to publish government press releases. It's just inherent in democracy. Now, they kind of put it on the basis of the division of powers, but nobody really believed it was the division of powers because all of the logic behind the decision operated as much against a federal imposition of such censure as against a provincial example. So when you get people like Sir Lyman Duff, and you move forward to people like Rand, and then you move forward to some of the civil libertarians like Boral Askin, we have, leading up to the Quebec secession reference, a long tradition of looking under the what we normally consider the principles of the Constitution to some value judgments which the judges make. I want to bring in here the Patrian reference, 1981. And I happened to be in the Department of Justice at the time, and I was in the courtroom for the argument of that case. And there was a lot of creativity going on. The federal government view is, show us in the Constitution where it says that we can't go to London and demand the patriation of the Constitution and the enactment of the Charter. Where in the Constitution does it say the provinces have any say in this? Yes, we pass a resolution in the House of Commons supporting the government's unilateral initiative, but as Robinette said, it had no more legal effect than a resolution wishing the Queen happy birthday. So far as the federal government was concerned, unilateral action was not only permitted by the Constitution, but it was really part of their responsibility to act on what they believed to be the best interest of the country. Well, Saskatchewan came up with this strange argument because the federal government was saying unilateralism is the way to go. The provinces were saying, no, you have to have provincial unanimity because of the so-called Pact of Confederation. And if one member to the contract doesn't agree, then the contract is binding and nothing moves until we have unanimity, which of course is a recipe for impasse. So Saskatchewan says, well, we think the federal government can act with the substantial concurrence of the provinces, a substantial number of the provinces. Where did that come from? I mean, if you look back, it really isn't in the constitutional history of Canada. It's never been clearly resolved one way or another, but one thing is certain, nobody ever formulated a convention that the federal government could only act with the agreement of a substantial number of provinces without defining what substantial meant. But the court grabbed it because it offered a way out, a practical way out. The court moved in a way that the black letter lawyers, Gartland, of course, was on the court at that time, and Ritchie and the old guard, and they were against, and Borelaskin as well, because he had a strong view of federal power. But then you had the Jean Betzes of this world who said it doesn't make any sense in a country like Canada on the federalist principle to permit unilateral action when the essence of federalism is multilateral attempt, at least, at consensus. And that, again, surfaces in the Quebec secession reference of 1998. But the point is, when you say judging the judges, is it really in the interest of the country as a whole that the court would have said, yes, Ottawa, you're right, move unilaterally, go to London, forget the provinces, forget the Aboriginal people who were claiming this special relationship with Queen Victoria and all her successors. When you see the bitterness arising out of Quebec's failure to join in, can you imagine the situation on a practical level that would have emerged if the court had given short shrift to all of the provinces and simply say, your vote, your voice doesn't matter at all? So the court moved, it seems to me, in a unorthodox, creative, rather bold way in support of what it viewed as the only workable vision of federalism. And that, again, flips back to the founder of this law school, Justice Rand, in the Margarine reference, the scope of the criminal law power. Jurisprudence up until then had been a crime is what the Parliament says is a crime. Montreal Railways case, clear, you don't question it. If Parliament wants to outlaw, sitting on a park bench, it's a crime. Rand, anticipating all the developments that I've been speaking about, says no. There has to be some kind of balance between the federal power and the provincial powers. And if you're exercising a federal criminal law power to protect the dairy industry, then I don't agree with all this law that has piled up in the Privy Council since Confederation that says a crime is whatever Parliament says it is. And you've got exactly the same argument that traveled forward into the National Securities Regulator released a few weeks ago. There is, the judges have, from time immemorial, said this balance has to be maintained because there is a federal structure. And that federal structure was brought forward in the secession reference as an argument to deny Quebec the right to walk out in the hypothesis of a positive vote. So I think the essence of what I'm attempting to say is to me, after 14 years on the Supreme Court and having had to read a lot of cases over that period of time, and looking at the judges who I think have made a really lasting contribution, they are the creative people who really had the boldness to carry the vision forward. Now, we draw a line under that because I don't believe judges should be judged by just how far they're prepared to go in pushing the envelope. I think there is equally a responsibility, as Chief Justice Dixon said in the Auditor General's case, for the courts to appreciate their role in the constitutional order. In other words, we're talking about structural problems here. We're not talking about individual litigants with a gripe against the government. How do the government institutions of Canada work together? And in the interpretation of the Charter, I think we see the court pulling back. Now, you probably hear the opposite from your professors, and I'm sure there are individual cases in which we could have a punch-up as we did at lunchtime. But the fact of the matter is that I was, as I say, in the Department of Justice in 1980, 81, 82. I had some tangential role in the development of the Charter. I know that the Charter that went from the Department of Justice to the Joint Committee of Parliament was a very watered-down version to what it became. I know that the people's representatives enlarged the Charter enormously. And if the courts had run with the license given by the Parliamentary Committee and the Charter as eventually put in place, we would have a lot more judging going on in many more fields of activity that we do now. So, you know, creativity has a positive aspect, the Quebec Patrian case, Quebec reference, but it also has a negative side to it, where the judges, appreciating their role in the constitutional order, say, hang on, we're not able to deal with this in a practical way. There is not the institutional competence in the courts to deal with this mandate. And the example, which actually I wrote about in a judgment, is Section 15, which we in the department forwarded as an anti-discrimination clause. And it was simply that you could not discriminate against somebody on the basis of race, religion, national origin, and so on. Essentially a human rights code type provision. Well, as you know, there were giant meetings of parliaments and committees, and this was gradually expanded through one amendment to the other until you have this whole introductory language in Section 15 about equal protection and equal benefit of the law. Without discrimination, but it does not say without discrimination on the basis of personal characteristics. That comes later in Section 15, where the drafters added, and in particular without reference to race, religion, and so on. Well, what that means, and what it was taken to mean by the courts in the early days, was that any classification which differentiated between citizens could be attacked in the courts. So you had a woman in Newfoundland whose husband was killed in a truck in a labor-related, job-related accident. She said, why should I be fobbed off with workers' compensation? Why can't I go, like anybody else, to the courts and claim in tort compensation vastly beyond what the workers' compensation allows? I do not have the equal benefit of the tort law, and I carry the burden of the workers' compensation scheme that other litigants don't carry. Then there's the municipal employee who wants to run for election. And he says, look, the Municipal Act makes me take a leave of absence. Other employees don't have to take a leave of absence without pay to run in an election. I'm being treated unequally. The Ontario court says, yes, you are being treated unequally. Charter remedy, Section 1, away we go. Government, justify it. Well, you can see where all of that was going. every legislation is nothing but classification. That's what it is. You do this and you do that, and you get this benefit and you don't, and you get this license and you don't, and all the rest of it. All of that would come before the courts under the introductory language of Section 15 for the courts to determine. And this is a doctrine that was espoused by, amongst others, Peter Hogg, who said, look, if you get unequal treatment, it's Section 1. And I was looking the other day at this book, The Scorpions, about the U.S. Supreme Court. And Robert Jackson made the statement, I regard it as a salutary doctrine that cities, states, and the federal government must exercise their powers so as not to discriminate between their inhabitants except upon some reasonable differentiation, fairly related to the object of regulation. What an enormous power for the judges. Enormous power. Well, I don't think it's reasonable. I don't agree that it advances the object of the regulation. And so the Supreme Court in Andrews said, look, this is all about discrimination on personal characteristics. Well, read the section. That's not what it says. And yet the court says, so far as we're concerned, that's what it means. Negative creativity, based on the court's view that we have to be realistic about how we operate within the Constitution, and there is no way that the courts can hear everybody's complaint about every classification made in every piece of legislation based on the Justice Jackson principle of reasonable justification. So you get this judicial retraction of power, saying we're not going there, despite the popular mandate through Parliament going beyond the government's recommendation, saying the courts have this power and we expect them to exercise it. They did something else that was interesting in the Charter. Section 52, as you know, says that any law inconsistent with the Constitution, including the Charter, is to the extent of the inconsistency null and void. Well, most of what you study here is private law. Now, I know this is a public law lecture, and we're supposed to talk about public law, but the fact is that most of our lives are governed by judge-made law, and according to the clear statement in the Constitution, the common law, to the extent it is inconsistent with the Charter, is null and void. So if you don't like a piece of the law of contracts or the administration of estates or whatever it is, you take that to the court, because not only does 52 talk about the law being inconsistent with the Constitution, but Section 32 talks about restraining the power of government, and that it applies to everything within the jurisdiction of Parliament or the provincial legislatures. And of course, all the common law is within the jurisdiction of the Parliament and the provincial legislatures. They can change it when they want. So it's caught two ways, the common law, Section 32, Section 52. Well, the courts say, well, we don't think so. Why not? Well, it may be true in Dolphin Delivery, Justice McIntyre says, it may be that the political scientists would say judges are exercising state power when they send somebody to jail. But for the purposes of the Charter, judges are umpires. They're not government actors. Well, you know, tell that to the guy who's just been sent to jail. Of course the judges are exercising state power. That's the only power there is. You know, if I'm sitting on the Supreme Court and I say on some of these cases that were complained about at lunchtime, you know, this is the result, Well, unless the state does something about it, it's just Binnie signing something that makes a meaningless declaration. So the state power is clearly implicated in everything that the judges do and in everything the common law deals with. But the court said, we're not going there. Again, we don't have the institutional competence to examine every rule under the Charter, and if we find there to be a problem, to demand the government, or in that case, the other private party, to bring forward a Section 1 justification. So the issue that we arrive at is that the courts act as boldly in restraint of their own authority as in other circumstances they act boldly to expand it, all in support of what I conceive of as the rule of law. Now, you know, when you look back and you look at Rand and the Japanese-Canadians case, and you look at Roncarelli and Duplessis, you say, of course he's right. Well, it's easy with hindsight. You know? But when the Supreme Court stood up and said, look, communists have as much right to free speech as anybody else, they were doing so in a climate that was just as vitriolic as the kind of anti-terrorist Islamophobe concerns that there being, you know, pedophiles, everything that people get excited about. And what concerns me is that, you know, will this generation of judges be seen in hindsight as having had the kind of courage that we so praise the predecessors? And in some cases, you know, you can take little bits and pieces of decisions and say that's great, you know, so on and so forth. But I'm talking about the kind of structural issues. And the one I want to leave you with is this question of globalization. And are the courts rising to the challenge posed by victims of human rights abuses in the third world with the complicity of corporations? Usually the corporations don't get involved in beating up people, but they benefit from it. And if complicity be shown, what is their responsibility? And it seems to me a very important challenge because Lord Tom Bingham, who would have been the Coxford lecturer had he lived, gave as one of his elementary principles of the rule of law that there be available a remedy. In fact, I have in my own little hand what he said. He said, means must be provided for resolving without prohibitive cost or inordinate delay bona fide civil disputes which the parties are unable to resolve. It seems an obvious corollary to the principle that everyone is bound by, entitled to the benefit of the rule of law, that people should be able in the last resort to go to some court to have their rights and liabilities determined. Well, we haven't solved this problem. There are a great many people, the people who are in the way of the Unocal pipeline from Burma, Myanmar to Thailand, the Rio Tinto mine in Papua New Guinea, the Monterico mine in Peru on the edge of the Amazonian rainforest. You know, you have this huge creativity in international law to deal with economic problems that have commercial dimensions. You have institutions called into existence. You have conventions agreed to. You've got the World Trade Organization up and running and going through a tremendous volume of work. But there are all these people in the cold, left outside. And is it consistent with the rule of law that the cost that they pay by having their lands taken without compensation, or by the violence that has been inflicted in some cases, some of it alleged, but some of it conceded? Or is it not consistent with our ordinary idea of the rule of law that those costs should be picked up and incorporated in the product and spread across the people who are taking the benefit of it? I mean, why should these losses fall on these people? Because the rule of law has not come up with some reasonable solution. Now, there's only so much the courts can do, but I leave you with this thought. The doctrine of the corporate veil, brought into existence to differentiate between the corporation and the shareholders, perfectly logical rule to deal with problems of corporate law and taxation and all the rest of it. But if you have as in the Monte Rico case, a company incorporated in Britain, and you've got a series of shell companies and an operating company in Peru, and the people in the Monte Rico case, the protesters were rounded up and held by the security police for a period of 3 days, during which somebody was murdered, somebody was raped, and there were acts of violence alleged. And there was communications back and forth with the head office in London. And yet London says, look, the corporate veil. These are all independent corporations acting independently. We were the passive recipients of information, but we had no authority to intervene. You know, should the court say, look, the corporate veil serves a very useful purpose for the reasons it was brought into existence. But we have to be circumspect in applying it to circumstances that it was never intended to deal with. And part of those circumstances happens to be this huge unresolved issue of, is somebody going to be responsible for the losses suffered by the people in the third world in this position? Now, that's just an example. The point I'm trying to make is that you can look back and you can say, isn't the common law great because of the way it developed under great judges? But there are huge problems facing our legal system at the moment in the environment and the commercial world and labor problems and so on and so forth. And globalization has vastly aggravated the problem of finding a useful remedy. There's not going to be an international tribunal called into existence. There are thousands of these cases. The Americans have been dealing with it under the Alien Tort Claims Act, but that's now up to the U.S. Supreme Court on the theory that it didn't apply to corporations. And if that is upheld, well, you can kiss goodbye about 5,000 pieces of litigation in the United States, which is really the only game in town for addressing these problems. So I would like it to be thought that 50 years down the road, in the same way as we look back 50 years to Ivan Rand, people will say that the judges recognized problems that they could do something about, and they had the courage of their convictions, and they had the boldness to implement those solutions in a creative way, respecting their role within the Constitution, but also respecting the responsibility they bear for upholding the rule of law. So with that thought, I leave you. Thank you.